cloud. Get started here, and I'm sure more people will show up. And so welcome everyone. I'm Susan Goodwin with the Department of the Interior's Office of Collaborative Action and Dispute Resolution. And I am Zooming in today from Boise, Idaho, where I'm sitting in a student union at Boise State, participating in a women's and leadership conference. I did some skill builder sessions on conflict management. So I'm really happy to have you all here. We are part of the Association of Conflict Resolution, and I'm one of the co-chairs for the leadership committee of the Environment and Public Policy section. If you're not a member already, please join or at least check us out on the website so you can find out about other events. And Diane, can you say hello?
Hi, my name is Diane Olson. I'm Zooming in from Salt Lake City, Utah. And I am working with Susan and the rest of the EPP section as co-chair this year. So glad that you're all here.
Great, great. And we have other members of the leadership committee. If you all could just say hello in the chat box, in addition to anyone else that can say hello, that would be great. And so I think that we are, well, we're up to 50 people already. So Mary, I see you came off of, you turned your camera on. Would you mind saying hello? Because Mary is our wonderful previous co-chair that handed the reins over to Diane and me.
Hi, and welcome. It's so good to have so many folks come for this conversation. Thank you so much for hosting, you two.
Yeah, great, great. All right. Oh, and there's Kelly. Kelly, want to say hello? You're also on the leadership committee. Excellent. And if I am not seeing anyone else that's on the leadership committee, oh, Stephanie Lucero, can you say hello?
Hello, Stephanie Lucero, calling in from Sacramento, California.
Excellent. All right.
Kelly Wilder's here.
Yep, Kelly said hello. Excellent. All righty. So, well, welcome. We are here to have a really interesting conversation that I'm very much looking forward to. And the topic, as you saw in the announcement, is with the overturn of the Chevron doctrine and perhaps other Supreme Court decisions that are related, what might that mean for collaborative decision making at the federal agency level? And we have some really smart and wonderful people that have agreed graciously to say some remarks on our virtual panel here, and we will be sure to answer questions along the way if you want to post questions in the chat box, and we'll also leave time for answering questions as at the end of this. So it's my pleasure to introduce our three panelists, and I am going to first introduce, let's see here. Now I have to just, I'm not working on multiple screens today, so I am going to switch over to first introduce Gail Bingham, who is a mediator in private practice, and Gail currently serves as the chair of the Missouri River Recovery Implementation Committee, and which is a congressionally chartered federal advisory committee to the U.S. Army Corps and the U.S. Fish and Wildlife Service. Previously, she served as the president of Resolve, a nonprofit consensus building organization founded in 1977. Gail has many decades of experience mediating a wide variety of environmental and public policy issues. She has extensive experience with negotiated rulemaking and testified before Congress on the Administrative Dispute Resolution Act and the Negotiated Rulemaking Act. And I could personally say that Gail is one of the main reasons I got into mediation and conflict resolution when about 20 years ago, she facilitated a really very productive meeting on the Colorado River that I was a participant in. And so thank you, Gail, for joining. So let me go to Will, and that's only because what I need to do, Michael, is hold on. I am going to, actually, I want to introduce Michael, and I'm just trying to find my window out of all these windows that I opened. Here we go. Actually, I'm going to introduce Michael next because Michael has been very nice to step in at the last minute for Kyle Danish, who was going to be our legal expert, and something came up in his busy legal schedule. And so Michael is also with Van Ness Feldman, based out of Washington, D.C., whose practice focuses on litigation, arbitration, mediation, negotiations involving transportation, energy, and environmental issues, as well as nuclear regulatory matters. And he maintains a strong and robust environmental practice, including counseling on nuclear regulatory issues, and also participated in the licensing of several nuclear reactors. He has experience litigating civil and criminal cases under NEPA, the Superfund statute, the Resource Conservation and Recovery Act, RCRA, Clean Air Act, and has a very deep knowledge of environmental law and has done some thinking and reading on the Supreme Court decisions from the last term, and really eager to hear his legal analysis. And thank you, Michael. Now, let me go to Will, and just give me a minute. Thank you for your patience here. Will Hall is the director of the DOI Office of Collaborative Action and Dispute Resolution. He happens to be my supervisor, and his second line in his bio, which I feel a little bashful reading, says he leads the incredibly talented and dedicated Cater team and coordinates with interior bureaus and offices to promote collaboration and effective conflict management in the workplace and for external matters. He's been part of this ECCR field for many decades. He came from EPA, where he was in our counterpart office there, and he's been with Interior since 2016. Before joining the federal ADR community, he developed Clean Water Act policy in EPA's Office of Water. He has his PhD from George Mason University School of Conflict Analysis and Resolution. All right, folks. So now that I've introduced our esteemed panel, I am going to turn it over to Will to kick us off.
Thanks, Susan. I can share screen, I guess?
Sure.
Oh, great.
You should be able to.
All right. Okay. Get this up. Second. Is that working?
It's working, but you're not in presentation view yet. And maybe you don't want to be, but there you
No,
go.
I do actually. Let me see.
Okay. Yeah, that's perfect.
Oh, it worked?
It was working, yes.
It was working. Yeah. Okay, there we go. Try that again. Okay. How about that?
Perfect.
Excellent. Thank you. I want to say, first of all, it's a real honor to be here today with Gail and Michael. Gail, I met decades ago, actually, as a very, very junior person. And it's great to have kind of the full circle sort of thing today. And Michael, it's really nice to meet you and looking forward to hearing your remarks. Thanks, Susan and Diane, for setting this up. Really do appreciate it. And let me just kind of jump in with a few thoughts to provide context for our session this afternoon. Okay, I wanted to start. I know a lot of folks here are familiar with the term ECCR, Environmental Collaboration and Conflict Resolution. We at Interior sometimes call it external collaboration and conflict resolution, since we apply these practices in areas that may or may not have a natural resources or environmental component. I think it's worth kind of deconstructing the words here a little bit to say that this practice is about directly engaging affected interest holders that are external to, in our case, Department of the Interior, but external to the decision-making agency, usually tribes, federal decision makers, perhaps from other agencies as well, in collaborative problem solving and conflict resolution. It's not just about the D word disputes or the C word conflict, but it's also about really trying to get people to work together in a positive way to resolve issues and sometimes even prevent or head off a conflict that might occur. It's really a range of processes under the heading of collaboration, negotiation, facilitated dialogue, et cetera. I'll spend a moment here in a bit on some of the details there. And conflict, of course, is definitely a part of this, and it's conflict or collaboration about environmental, energy, public lands, natural resources, and interior cultural resources are also a really important thing. And these are sometimes framed as issues, and sometimes they're framed as conflicts or disputes. It really depends on the orientation of the participants in these situations. And lastly, resolution. And that sometimes involves the use of a neutral third party, such as a mediator or facilitator, who helps the principal parties or interest holders or participants in negotiations and dialogue. But they themselves, as a neutral third party, have no interest in the outcome. In the legal profession, they often talk about neutrals, right? They use a shorthand for that. And so this is kind of what ECCR is. And I'd be remiss if I didn't take the opportunity to note that we are now celebrating 50 years of this practice of ECCR. The first environmental mediation, is what they called it back then, took place in 1973 and 1974 on the involving the North Fork of the Snoqualmie River in Washington State. There was a serious issues related to flooding there, and they were working on a dam that would do flood control on that North Fork of the Snoqualmie River. Jerry McCormick and Jay McCarthy were the mediators way back when, and they kind of got us all started in this practice. Now, of course, people have been negotiating and working out issues on environmental issues for eons. This is the first time that I think we as a field named this and said, yes, this is environmental mediation. I think it's useful to talk about the spectrum of ECR, environmental conflict resolution, or ECCR processes. This is a graphic that I borrowed from EPA, showing perhaps my history there, having worked with EPA before. Often in the field, we break down the types of processes or the context in which we use this practice into upstream and downstream. Some actually allow for a midstream. And so there's a spectrum of situations that might benefit from the use of a collaborative process. On one extreme, you have parties or participants who are very broadly defined. It can be a really large group sometimes that work more upstream on issues. Whereas when it gets to the downstream side of things, it tends to be in the context or shadow of a litigation process, whether that's administrative litigation or judicial administration litigation. And at that point, it's usually the so-called named parties, the people who show up who have filed a complaint or are responding to a complaint. Now, the dividing line in there, I think, can be seen in a number of different ways. This dividing line, that dotted line you see, kind of distinguishes between dispute settlements in courts and other things that happen more upstream. I, for example, would probably put it a little bit to the left of enforced regulations. For me, that line is either it denotes either pre-decisional type things where an agency is still working on a decision, trying to come up with a decision, hasn't made it yet, and those where some decision has been made, like a regulation, a policy, et cetera. And in that context, sometimes people challenge those decisions in court, and sometimes they don't follow the decisions, which can result in agencies choosing to undertake enforcement actions against alleged violators. So for me, I would move that just a little bit to the left. But suffice it to say, there's this range of things, particularly upstream, where ECCR can be particularly helpful. Sometimes it's just, getting some convergence or agreements on issues. Sometimes it's about providing advice or recommendations, like in the context of a federal advisory committee. Sometimes it's NEPA, National Environmental Policy Act, developing a plan to manage the landscape or a plan to address endangered species type issues. I've been involved over the years in a number of matters where it's policy development. The agency is seeking experts to come in and essentially advise on what a good policy would be for a particular environmental issue. Negotiated rulemaking doesn't happen as much anymore, but it can be a really powerful ECCR process where agencies develop a proposed regulation using a negotiation process and then propose that regulation for the usual notice and comment process. This can be about locating a facility or project as well. So this is, I think, a helpful way to kind of categorize where an ECCR process might be used. Some benefits of ECCR. So back in 2018, I was part of a group of federal employees that was connected with the Federal Interagency ECCR Forum. That's been around now for, almost 20 years. It's amazing. And so we put together this piece that's available, I think, on the web someplace. We could certainly share it if you can't find it, about the benefits of ECCR. And as it turns out, there's actually a pretty robust literature on the subject that speaks to three types of benefits in particular. One of those is time and money savings. And the idea here is that ECCR can produce cost savings and more timely decisions for taxpayers and for federal agencies, compared to litigation and other, if you will, more conventional type processes. And there's several examples mentioned in the report from state ECCR cases and federal ECCR cases as well. The second thing that it can do is improve relationships between the government and interest holders. And there's a number of examples as well from the research about this related to land disputes that came up. And just, working relationships in federal and state ECCR cases that people have reported, their relationships are better as a result of participating in the process. And of course, lastly, we used to call it the $64,000 question. Is it the $1 million question now? I don't know. About improving outcomes. So the real goal of these processes is to have better environmental outcomes, natural resource outcomes for the public. And the idea is that ECCR can bring creativity in areas where people aren't thinking creative enough. It can create more durable solutions that are more likely to last and address entrenched disagreements that exist. And one thing in particular that ECCR does is produce high settlement rates from the research that we have, which is pretty cool when you think about it. And so there's, the report's really worth looking at because it does have some great examples from the research. One of these days, we should probably go in and update it and see if there's anything new out there. I wanted to note a little advertisement here for my federal ECCR center, as well as some others that are out there. I noticed just looking through the list of participants that a number of the other federal ECCR centers are present today. There's, of course, our Office of Collaborative Action and Dispute Resolution, EPA's Conflict Prevention and Resolution Center, the Collaboration and Public Participation Center of Expertise over at the Army Corps of Engineers, FERC's Dispute Resolution Service, that's the Federal Energy Regulatory Commission, and of course, the National Center for Environmental Conflict Resolution at the Udall Foundation. And these exist today, as they have now for, a couple of decades or so, as really institutional examples of how the federal government has said, yes, ECCR is a powerful tool, it's a powerful process that we can use, and it's worth dedicating the internal resources to have expertise and to interface with the private sector practitioner community so that parties, participants interested in these processes get the best expertise to work on the really tough issues that they're facing. All of our centers have certain key authorities we work under. The Administrative Dispute Resolution Act of 1996, which authorizes the use of so-called alternative dispute resolution, which we use in environmental and natural resource contexts. Negotiated Rulemaking Act, which authorizes the use of facilitated process to develop proposed rules. And there's also this policy memorandum first issued in 2005, then in 2012, on the use of ECCR in the executive branch. And that I note the two dates because this has been a bipartisan interest now for quite some time, as was, of course, the ADRA and the Negotiated Rulemaking Act back in 1996. Worth looking at some trends over time. These are federal ECCR cases from FY 2008 through FY 2022. And if you look at that orange line at the top, you can see the aggregate of all of the agencies. And the trend over time, if you draw kind of a straight line through it, is up. And I recall, Gail wrote this great book some years ago, at the time, kind of cataloging ECCR cases that had existed at that time. And I'm sure we well more than doubled the number that existed at that time, even just in the federal sector. So it's a testament, I think, to the value of this practice to federal agencies and others, that the work has grown so much over time. And I'll just end with this. Sort of what prompted this webinar. Maybe I get some of the blame for prompting it, because I was musing on the recent decision, Loper Bright, and some of the other cases. As a non-lawyer, I should say, I'm not an attorney, and I reflected back to my early days, working in Clean Water Act programs at EPA. And this was, for me, this was early 90s, and the Chevron decision, I guess, was back in about 84 or so. And it was pretty commonplace for us as regulators to talk about Chevron and realize that it was there and realize its importance. We always did our best work to have a good record, to make sound decisions and those kind of things. But we knew it at the end of the day that was something that courts were going to look at. So I'm wondering, thinking back to those early days as a very junior federal employee, wow, what's changed? And so, what did the Supreme Court decide in these cases, including Loper Bright? And what might those impacts be for people that are in the regulatory community, the regulated community, and the public? So I want to learn more, and as I hear more, I know how little I know really on the subject. But this led me to some other questions. And so we, as ECCR practitioners, I think, are often the optimists in the room. We're the ones that think, hopefully, about what's possible and about collaboration and how we can help people get through tough issues or impasses that they have. We also are the people in the room asking lots of questions. And so these are my further questions on the subject. What impact might these decisions have on the willingness to use ECCR, including negotiated rulemaking, especially for the federal agencies? Does this change what we often refer to in this business as the best alternative to a negotiated agreement? Does it change that thinking, that analysis that agencies put into choosing whether to collaborate or not? Could the decision shift where and when ECCR occurs? In my work here with the team here at Cater, we're, of course, a lot of it's pre-decisional, right? It's more upstream. And we bring facilitators in to help with that. We're, of course, very aware that sometimes people are on the courthouse steps when they decide to use ECCR. Could these decisions, could Loper Bright change where people choose to do a collaborative process? How are the courts likely to view efforts to collaborate and engage interest holders through ECCR in the post-Chevron context? I don't think there is a sort of deference given to collaborative activities that take place when agency decisions are challenged in court, but maybe there is. But how could this change how the courts view those types of situations? And then lastly, again, quite optimistically, might ECCR help agencies and their interest holders, the parties that are interested in the work that they do in decision-making during this period of policy uncertainty? And that's kind of, again, I think optimistic, and where I'll leave this, Susan, to hopefully prompt the thinking for our other panelists, but also the broader community that's joined us today. Thank you very much.
Great. Thank you, Will. All right. We are going to turn to Michael, and let me go ahead and get your slides up here. And let's see here. Okay. Where are your slides? 1 second. Let's see. Post Chevron. Okay, bear with me one second, folks. Share the screen. And why am I not seeing it? Let's see here. Ah, okay, so that was, no, that's Gail's. Sorry about that. Let me go ahead and while I'm fiddling with the technology here, anyone have any questions to start with? Feel free to post them in the chat or raise your hand. And
Susan and
yeah.
panel, there's just one question on whether the panelists would be open to sharing their slides after this meeting. Will, thumbs up from Will. So Will, thank you, Gail. Michael, you'll let us know if that's something you're comfortable with. Otherwise, we do make the recording of the webinar available after and we post that online. So
Great. Thank you, Diane. And Diane, can you check, give me a check? Am I showing the right screen?
yes, yep.
Okay. Michael, you're up.
Can you hear me all right, Susan?
Yeah, just maybe a little bit closer to your speaker.
Hear me now?
Yeah, how does that sound, Diane? What do you think?
It's a little faint. You were much clearer earlier when we first started the call, Michael.
Well, I'll see. I'll try to get as close as I can. Is this any better?
That is better.
Great. Okay. So Susan, I'll ask you to advance the slides. So
Sure.
I'll just start by saying I'm grateful for the invitation. As Susan indicated, I am with a private law firm, Ness, Feldman in Washington, D.C. But I should say that we're oftentimes on the side of agencies, not just against agencies. So I really don't have a pro or anti-agency bias in these remarks. And in fact, at the present time, I'm on the side of an agency in a couple cases and against an agency in a couple others. So I do a lot of appellate work, and my remarks, I think, will probably reflect that. So next slide, please. Just to set the stage. Oh, and by the way, Diane, you asked if it was all right to share my slides, and it is. So how did we get here? Well, the Supreme Court decided Chevron, and there's the name and the site for the case in 1984. So realize, first of all, that the country was around for almost 200 years before we had Chevron. So to the extent that some people think that somehow the Supreme Court has thrown out something on which the Constitution is founded or something, it's not really the case. And in fact, as Chevron evolved, I think it evolved differently than perhaps the justices at the time actually expected that it would. But in any event, what was it about? EPA and the Carter administration had, after the 1977 Clean Air Act amendments, defined a source as each single emissions source in a facility. But then in 1981, as many on the call will be familiar, when one administration changes to another, particularly when the parties change, EPA switched to an interpretation that the entire facility would be treated as the source, using what came to be known as the bubble concept. Next slide, please. So can you advance that? There you go. Thank you. So the DC Circuit rejected EPA's interpretation of the bubble concept and really relied somewhat simplistically, I would say, on the notion that the Clean Air Act generally required maximum reduction of emissions. And it's a lot more complicated than that. And so in the Supreme Court, no one actually supported that interpretation of the Clean Air Act. But the court held that unless the intent of Congress was clear, courts should defer to a reasonable interpretation of an agency's governing statute. Now, note that there's a lot packed in that statement. First of all, we have to be talking about an agency's governing statute. in this case, EPA and the Clean Air Act, clearly it was a governing statute that EPA had the sole authority to administer. But if we had been talking about the Freedom of Information Act or the Administrative Procedure Act or other general statutes, agencies do not and never have gotten deference in how they interpret those because they apply to more than one agency. And so we ended up with this two-step process that in some ways almost morphed into more steps, but at least initially, we talked about Chevron step 1, Chevron step 2. Well, what did that mean? In step 1, if the intent of Congress was clear, that was the end of the matter. But in step 2, if the intent of the Congress was not clear, if the provision could be reasonably described as ambiguous, then an agency's reasonable interpretation would be upheld. Next slide, please. And so we got into additional steps, and we don't, I think, have to debate what all those are, but it got more and more complicated. And I think a number of practitioners and a number of justices over time thought that Chevron had kind of morphed into something more than was ever originally intended. And as my last bullet indicates here, at least one set of statistics that I've seen shows agencies, if they got to step 2, that is, if the party challenging the agency didn't prevail at step 1, or the agency at step 1, that is, if the statute was clear, that's step 1, and one side or the other can win, and that'd be the end of the case. But if it's not a step 1 case and it gets to step 2, the agencies were winning as much as 94% of the time. And a lot of people got pretty cynical, frankly, about that. And it wasn't even perceived as worth litigating some questions anymore, even though people in the field thought that there was a lot of things that could be debated about what agencies had done in particular instances. And when it got to be particularly galling to some of us was when the agency would say that the statute at step 2 reasonably meant X, and then, a few years later, the same agency construing the same statute would say that it meant 180 degrees different or minus X. And that didn't breed a whole lot of respect in the process, frankly, for some people. And I think that kind of permeated and elevated itself up to the level of the Supreme Court. And so, frankly, by the time that Justice Gorsuch arrived in 2016, that was the last time the Supreme Court ever cited Chevron until we get to Loper-Bright, which is itself kind of remarkable because a lot of us could see what was coming because the court was simply deciding what was the best or correct interpretation of a statute without going through the Chevron step 1, step 2 process. The lower courts were going through Chevron step 1, step 2, et cetera, but not at the Supreme Court. Next slide, please. So what was happening was that people were opining, law professors who spent a lot of time analyzing these things. It was assumed that there was some kind of a deal that none of the justices would say Chevron so that they wouldn't get into a debate about it. And perhaps that was the case, but by the time Loper-Bright got cert granted, it turns out that maybe the parties, the justices who were opposed to Chevron were just waiting for the right case, and Loper-Bright appears to have been that case. Next slide, please. So what we had in Loper-Bright, it was a Department of Commerce fisheries statute, and the statute in question provides for monitors to be present in 3 specific maritime areas, and that the fishing vessel operators on whose vessels the monitors would be present were required to reimburse the federal government for such monitors. So the statute then, at least as many of us view it, was silent as to the other maritime areas. And so some would argue that the statute was clear that Congress intended reimbursement for the monitors in the 3 specific maritime areas provided in the act and not elsewhere. But next slide, please. That's not how the DC Circuit came out on it. The DC Circuit reviewed the case and construed silence as congressional intent to defer to the agency, and upheld the agency's determination that outside the 3 specified maritime areas, the expenses of the monitors on the vessels could also be made to be reimbursed to the federal government. And that was a bit of a breathtaking decision in the view of many of us, because it's a little hard, in my opinion at least, and an opinion I think of others, to say that when Congress is silent, that intends the agency to adopt a reasonable interpretation of the statute. How does an agency go about doing that when the question is on a blank slate? In any event, Loper Bright quite wisely, back one please, Susan. Loper Bright hired one of the luminaries in the field, former Solicitor General Paul Clement, and he proposed 2 questions on cert, the first of which was whether the DC Circuit's decision was a correct interpretation of Chevron, and the second of which was whether Chevron should be overturned or at least clarified. And the court only granted cert on the second question. So that led a lot of people to say, okay, well, Chevron is gone. And that was probably a fairly accurate prediction, but we're going to see that it's not entirely so. So we got to the oral argument, 2 cases back to back. Another case, Fisheries case, came along and got consolidated. Court heard argument in both. The other one came out of the First Circuit, which refused to say whether it was a Chevron step 1 or step 2 case, by the way. So the 2 courts of appeals couldn't even interpret the same statute in the same way. And almost immediately, the Chief Justice, who's very steeped in administrative law, asked Mr. Clement whether it would be appropriate, whether if the Department of Transportation hypothetically was given authority by Congress to determine the appropriate length of a truck in interstate commerce, whether that implied a degree of deference, which was a very interesting question. And I knew almost immediately when I heard that we were heading to a more nuanced outcome than a lot of people may have been predicting. And in fact, later Justice Kagan, not always on the same page with the Chief Justice, came back to a point similar to his, which I interpreted as trying to find common ground with him. And she referred to statutes that use terms like just and reasonable to determine a rate. Next slide, please. So what happened then was you can move on. I'm sorry, I anticipated this slide already. Next slide. So I was pretty certain we were going to see an opinion that said that deference was not gone for statutes in which Congress used terms that implied deference to the agency's interpretation. And you will find discussions of this at pages 17 and 26 of the majority opinion, where words like appropriate and reasonable were used by the Chief Justice to say that in those circumstances, the court should infer that Congress intended deference to the agency, a la Chevron. So Chevron, in that sense, has not been completely overturned. You could quibble with me and say, well, it has, okay, but there's a similar principle that's still going to govern in some cases, depending on how statutes are written. Next slide, please. So I think there are 3 takeaways here. First is deference is still due to an agency's fact-finding if supported by substantial evidence under the Administrative Procedure Act. This is particularly true of technical matters. The second principle is that deference will be due to an agency's construction of its governing statute if Congress used words that imply deference to the agency's interpretation. And the next slide, please. And 3, the court went out of its way to say that it was not in holding that all prior cases that relied on Chevron could be relitigated simply because of that, but rather the doctrine of what we call stare decisis would apply. And that means that there's a hurdle that one has to get over in order to relitigate an issue that's previously been litigated and decided, even if not against the same party. So, and I would also say, kind of as a corollary to this, that if the agencies don't want to see any chance of a prior ruling being relitigated, they might just avoid reopening the matter. That's not always possible, I understand. In any event, next slide, please. I should add that the Federal Energy Regulatory Commission recently came out with a decision after I sent these slides to Susan, and I want to share that with you so you have some idea of how this is beginning to evolve across the agencies. It's a case called Total Gas and Power North America, Inc., and some other parties. Docket number IN 12-17-000. And the agency on September 19 terminated the hearing that had been scheduled and holding the proceeding in abeyance as the district court had ordered, because it was a proceeding to determine if penalties were due under the Natural Gas Act. And the Federal Energy Regulatory Commission determined, because of the Supreme Court's decision in Jarchese, that because that case involved a situation in which securities fraud was designed to punish and deter and not to compensate, it was a type of remedy at common law that could only be enforced in courts of law. And some of the interpretations of these statutes that the agencies have applied previously in cases like this were based on Chevron. And so if there is a pending enforcement action like this, you can see the implications of both Jarchese and Loper-Bright. That FERC has not decided whether to go to court, I take it, against Total instead of before an ALJ. And it's going to have to decide whether its prior interpretation of Section 4A of the Natural Gas Act, which pertains to manipulation, is something that it's comfortable litigating in court. So that's a bit of a taste, Susan, I think, of what may be coming about how these two Supreme Court decisions are going to be construed together. And then finally, there was the decision in Corner Bright, which allows a party who's just been injured and maybe wasn't injured when a rule was adopted previously to sue under the APA because the action accrued within the last 6 years, whereas agencies had preferred to say that once more than 6 years had passed since a rule was adopted, they were immune from challenge unless an agency reopened them. And the court disagreed with that, saying that if a party was injured within the last 6 years, the cause of action has just accrued and they can sue. So the three decisions are going to make a difference, no question about it. But I think agency decisions are still going to get a fair degree of respect when it comes to interpreting their governing statutes. And I'll just say that in the nuclear field in which I practice, as Susan said, there was a Supreme Court decision in 1960 called Power Reactor, where the court said that there couldn't be an area they could think of where they'd be more deferential than nuclear regulation because Congress obviously intended that the people who were doing the regulating and who had the technical skills far exceeded those of the courts. And so I think when you see technical areas in which agencies have a long history of knowledge and expertise, the courts are certainly going to listen and give some respect to the agency's interpretation, even if it isn't as deferential as we used to see in Chevron. Anyway, Susan, I'll stop there. Happy to answer questions.
Great. Thank you so much, Michael. There is a question in the chat box, and feel free for everyone else to push your questions in the chat box if you want. And so, Michael, the question from Ken Rosenbaum is, one of the early comments on the Loper Bright case was this will encourage litigation. Parties that don't get an interpretation of law that they like from the agency will get a second chance by taking the agency to court. Do you agree? Will these kinds of cases be amenable to mediation?
Well,
Good
let me
questions
take
there.
first half of that first. I do agree that to some extent there will be some more litigation now, especially if the agency hasn't already decided the matter and stare decisis doesn't apply, and the agency would have been looking for deference under a so-called reasonable construction of an ambiguous statute. But at the same time, when I presented this internally a while back, one of my partners said to me, "You don't sound like you think this is going to be as revolutionary as a lot of people think it will." And I said, "Well, I think that's true too." And they said, "Well, then why did the court grant?" And I said, "I think for two reasons. First, where a statute is silent, I think the court was offended that the DC Circuit ruling and other rulings like it would say that implied some degree of deference to the agency. I don't know how you get an implication of deference out of nothing. But secondly, and more important, because most statutes are not silent, I think the court had become persuaded that this business of construing statutes to flip back and forth from one administration to the next every 4 or 8 years produces so much uncertainty, and people can't rely. People will invest hundreds of millions or billions of dollars in projects thinking they're on the side of the law, or in designing automobiles or trucks, for whatever the appropriate emissions regulations are, or a myriad of other types of examples we could come up with. And then they proceed to make their investments and conduct their affairs accordingly, only to find 4 or 8 years later that the agencies are construing the statute to be entirely different than what the party had understood the statute to mean. And I think, therefore, the court felt that the provision of the Administrative Procedure Act that says that it's for the courts to determine what the law is means that the Supreme Court, even with some deference for the sort of factual findings and other things that I referred to, will decide what the correct or best interpretation of the statute is. And then, absent some change by Congress in that statute, that's the law. And then parties can proceed accordingly. And that doesn't mean it's pro-industry. It doesn't mean it's pro-environmental group. It doesn't mean it's pro-anybody. It just means the law will be what the law was intended to be, at least as the court sees it. And if parties don't agree, stakeholders don't agree, they can go back to Congress to change it.
Okay. And another question in the chat for you, Michael. Do you think that the courts will fall back on the AIR deference, AUER deference, persuasive but not binding?
Yes, I was sort of trying to generalize toward the end by saying that I think that there's a whole prior series of cases, there's Skidmore deference and AIR deference and this and that I kind of summarized by saying that I think that the courts are still to give some respect, if you will, to the agency and its interpretation, especially if it's had a long, practice or experience with how things really work. And I can tell you, Susan, to answer that question, I argued a nuclear case in the DC Circuit about 15 or so years ago, and it involved how the commission now regulates the licensing of new facilities. In that case, they were enrichment facilities, but it's the same regulations that govern reactors. And I remember Judge Kavanaugh was on the panel, and then later I was on a court appointed committee with him years later, and we got to talking about the case. And he said, Mike, we don't really need your help to tell us what the law is, but where you're so helpful to us is because you put things into context so that we understand the ramifications or potential ramifications of what we're going to do, and so that we don't miss anything. And I think that's kind of the point, that the same would apply to agency counsel. I was supporting the NRC in that case, of course. What the courts have meant by prior types of deference, whether it's air, Skidmore, or whatever it may be, is that the agencies still get a certain degree of, if not deference, respect in how they interpret and apply statutes. And if there's a sort of what should I say, a consistency to it, a rationality to it, that it's based in evidence, and maybe that it's been longstanding, all those kinds of things are going to give the agency, something that may, to some people, seem like at least a bit of deference.
Great. Yeah, and who knows, maybe deference for decisions that have been reached collaboratively with interested parties might be helpful
Yes.
at this point. Stephanie, you have your hand up.
Yeah, I've been having a lot of discussions on Loper Bright. So one discussion I heard over the weekend was discussing that, one of the possible factors of this case for courts, and this kind of leads to the information that agencies would want to produce or co-produce with stakeholders in justifying their interpretation or increasing the deference the court would provide, is that there's almost in some cases, because the judge has to determine whether or not in that first phase, is this ambiguous, was the congressional delegation of deference clear to the agency. There's also this requirement for justices to have a better understanding of the types of questions to ask. And so that comes up a lot in our work as practitioners of ECCR. Are we asking the right questions? Are we posing the right questions? And so I'm just wondering if you have some thoughts on maybe that could be in another layer that in our field we could support this agency deference and helping craft the right questions, maybe resolving conflicts on the science or the science being used to determine an agency decision, just thinking through what I know in our field.
But so that's a very good question. I could go in a number of directions with it, but let me try best what I think would be most helpful. And that is, right at the end, you were referring to findings and technical matters. And so, to reiterate what I was saying before, if the Nuclear Regulatory Commission makes a determination that a particular system is going to provide an adequate, reasonable assurance that public health and safety will be adequately protected, those are the words of Atomic Energy Act, no court is going to fail to give deference to the agency's technical findings on a matter like that. And similarly, maybe bringing it more to types of ECCR discussions that Susan and Will and maybe you are involved in. If agencies get together with stakeholders and come up with environmental remediation plans, how to restock salmon in the Pacific Northwest, or how to work with the states that have an interest in allocating Colorado River volumes, or you pick the question, and there's a long degree of collaborative process based in science and technical findings supported by substantial evidence. It's hard for me to imagine that the result of that collaborative process is not going to get, at least as I would refer to it, respect, and maybe even a little more than that, kind of a thumb on the scale, where a judge would then look to somebody who was challenging that and arguing that that result should not be given any kind of deference or even respect or weight, however you want to refer to it. And I think most judges would be pretty skeptical. Now, I will say that I've been monitoring some litigation in the Fifth Circuit involving nuclear regulation right now and storage of spent nuclear fuel off-site at what's called interim storage facilities. And the court was not in the least deferential to the Nuclear Regulatory Commission and its interpretation of the Atomic Energy Act. And I think, frankly, the court was wrong. And there are cert petitions pending, which I have a feeling are going to be granted next week. And the court will probably hear the case next late winter or spring, but there's never any certainty in that. But the Fifth Circuit has become a bit of an outlier, and I think not having a great deal of respect or deference for federal agencies. And you see it in any number of areas, whether it's abortion pills or vaccine mandates or rent control or whatever it may be. But that's kind of an outlier, as I say. I think in just about every other circuit and in most federal courts in the country, when agencies make findings that are based in evidence and that are in their wheelhouse, they're going to get respect. Now, when an agency goes outside its field, and I'm involved in FERC licensing, for example, of hydro facilities, and one part of the Clean Water Act gives EPA the authority to determine water quality standards unless a state grants a certificate within a year. Well, then the state or the EPA get the deference, not FERC. So you have to look on it in a somewhat nuanced matter. But I think the bottom line point is that when you guys engage in negotiations that go on for months or years that lead to a very thoughtful, comprehensive, rational agreement that seems to be working, anybody would expect that the momentum would be on the side of the people in agreement and the agency in particular.
Great. Yeah, thanks, Stephanie, for that question. Thanks, everyone else, for your questions. We're going to move on to Gail and hear about her musings on the use of ECCR, her very long experience in the ECCR field. And so let me bring up your slide deck, Gail, and show the slides. Okay. Am I showing the correct screen?
Yes.
Okay.
Can you hear me?
Yes.
All right. Well, thank you, Michael, for giving us just a really thoughtful and much more nuanced than I've heard ever discussion of Loper Bright. I think that's just been wonderful. And to Will for his questions, you can go to the next slide. And I want to cover 3 broad topics and then just have one slide about resources. And the first has to do with Will's question, really. I think that Michael's context is just very powerful. I personally, as a mediator, don't presume to answer most of your questions, Will, because they're predictions. But what I am, that you said, is optimistic. And I do have a few ideas and suggestions that maybe I'm hoping will be helpful. And again, as Will said, I want to talk about the tools we have as professionals to bring to the table. We're talking about a hugely varied landscape of situations, and appropriately need to think and discern about what tools are appropriate for what situations. What hasn't changed, in my view, are the kinds of challenges and the stakeholders to the agencies and their stakeholders have. Those challenges haven't changed, and neither have the principles of our practice, in my view. We continue to learn and improve, of course, but I'd like to talk a little bit about building on what we've learned. It's not a how-to, but I think there's a depth of knowledge in our field that is worth reminding ourselves about. Next slide. So in terms of the context, yeah, there we go. I would have changed this. Circumstances have changed in a major way. I'd defer to Michael's judgment about how major. I think it's really very useful to think of a nuanced way. He said, I saw somebody in the chat was asking about BATNA, the best alternative to a negotiated agreement. And that's one of the things that's sort of at the bedrock of understanding people's motivations. And it seems to me that the fact that Loper Bright came forward suggests to me anyway that at least some regulatory decisions went too far in terms of satisfying the concerns of the range of public that have a stake in that. And the other thing in terms of the current circumstances, and Michael touched on this, I think, is that we're in a world a little bit of uncertainty for agencies about the factors that they're going to take into account in making decisions about what processes to engage in. And there's likely to be different perspectives amongst lawyers about the implications of Loper-Bright. What I do think, and jumping down to actually to our role, that mediators and facilitators can offer in the face of that kind of uncertainty is experience and confidence in the value of engaging in an assessment of each situation. And I'm an advocate for shared assessments with those who have a stake, because if you don't, you run the risk of causing folks to go to the other forums. There are multiple forums in public decisions for people to go to satisfy their concerns. So we also, I think, in addition to being experienced and confident in the value of assessments, we also have process instincts about the range of tools and what, when you need a hammer and when you need a screwdriver. And we're a voice for opportunity, for that optimism about the value of collaboration. And so to the other part of the context, which is the point about the variety of circumstances, even at the policy level within rulemakings. You all know these things. Some situations are really early. This a bit is the upstream downstream that Will was talking about. But is the situation one in which people see a problem and know they have diverse interests, but they're early in sorting out the dimensions of the problem and the options for consideration of it? Or are we far down the road to where a specific proposal is being put forward and people have concerns about it, and it becomes a dispute over a specific decision? The tools vary in those circumstances. They also vary in terms of how complex or uncertain those scientific, technical, or economic issues really are. So in the Missouri River Recovery Implementation Committee, Mr. Rick is fondly known as, this is an advisory committee to the Corps of Engineers for the environmental impacts of the 6 main stem dams on the Missouri River. One of those impacts is the listing by the Fish and Wildlife Service of the pallid sturgeon as an endangered species. Everyone, I believe, involved, both agencies and all the stakeholders, have recognized that there are tremendous scientific uncertainties about what aspects of the channelization of the river, the levees, the wing dikes, and the dams themselves, the controlled releases, what aspects really are the ones that contribute to the low population, and how much lower is it than it used to be? It's a very rare fish in a very muddy river. And so there isn't good data even on what the change over time has been since pre-dam or post-dam. So those uncertainties have led these parties to engage in adaptive management kinds of collaborative learning processes that are applicable. That's not always applicable. And then, because I had the chance to see Michael's slides before this, the Loper-Bright question might be, does the legislative language include a wording that implies deference? So that's a question there, and there are many, many more. Next slide. So as we all have been saying, or as I just said, you need to have different tools to meet different challenges. And so if I were to encourage one thing as opposed to predict anything as a result of Loper-Bright, I would encourage agencies and stakeholders alike to consider much more frequent, if not routine, use of situation assessments. That is not as inexpensive a tool as a full-blown formal negotiated rulemaking, but it will allow the agency to use the right tool in the right places. And I think that could be done by internal independent professionals, such as those in the centers that Will listed, or professionals outside the agency as well. The assessments need to be both internal and external. There are usually multiple offices within an agency that have different expertise and perspectives on both the issues and the process. So general counsel's office versus the Office of Policy versus the rulemaking office versus a science office. And I don't really mean versus, but each bring something to the table, and their insights are of value in these kinds of assessments also. And even if it just stops with that kind of assessment, which I would hope it wouldn't, I would hope there would be some kind of step that would be efficient and also targeted and useful. Assessments can be intentionally used as a tool in themselves, as a first step toward building a collaborative relationship. And that's why I have always liked the word shared assessment, or the phrase shared assessment. And then it is incredibly valuable, as I'm sure everyone on this call knows, that if an agency steps forward with a suggested process, no matter how well-intentioned or how well-designed, it will work best if there's both understanding amongst those who you're wanting to participate in it, and alignment on what that process option, what the intended outcome is, who should be involved, et cetera. So if I were to make one kind of plea, as opposed to a prediction, that would be what I'd hope you would remember. I wrote a monograph at the 25th anniversary of Resolve, which was back in 2003, 20 years ago, oh my goodness, that was called When the Sparks Fly, Building Consensus When the Science is Contested. And it focused on the last of these challenges, the technical complexity and scientific uncertainty that I mentioned before. But it's also important, I just wanted to remind us of what we already know, that the kinds of challenges in public issues include the fact that there's many parties, that they're organizations, not just individuals, generally speaking. There's multiple issues, many forums for decision-making. These are public and political issues, and that there's unequal power and resources amongst the parties that can get in the way of an effective collaborative process. So these kinds of sort of basic list of challenges and many more, just to remind us of those. So next slide. So again, some basics to remind us of, just to really reinforce that there's a lot that this community brings to the table. The critical choices, so an assessment, I should say, can go beyond a description, and I think should go beyond a description if it's a collaborative assessment, and be used intentionally and actively for making choices about the next steps. So what's the objective? It's probably shouldn't be the last one, should be the first one. Whom to involve, what the timing should be, and a variety of other kinds of critical choices. The stakeholders, just to underscore my point about collaborative assessments, they have questions about whose goals are plans trying to achieve, whose alternatives are being analyzed, whose criteria are these alternatives being analyzed against, and whose questions are being asked. I did some minor research at CEQ years ago for a book on the 25th anniversary of NEPA on the role of collaboration, and they allowed me in to look at the documentation of NEPA cases over that 25-year history. And the most frequent filing, if you will, the reason for litigation was that a party thought there was insufficient analysis of the alternatives, that there were alternatives missing. So it wasn't just that they disagreed with the decision. So just to underscore how important that question of whose alternatives are being analyzed really is. I'm going to talk mostly now about negotiated rulemaking. I do think it's an option worth considering in the context of Loper-Bright. Michael made a really great case with Stephanie. Also, though, about joint fact-finding. That can be a standalone process in and of itself of great value. Obviously, workshops, interactive roundtables, charrettes, but again, sharing the process of thinking through the situation and what various people would be wanting to accomplish and what their concerns are about having a collaborative process, because people do have concerns about it. Are all that plus all of the kinds of tools that are on some of the spectrum slides that we all know. So, but next slide, sort of just reminding ourselves one last thing before I talk a little bit about negotiated rulemaking. There's a lot that's in common about these diverse processes, these range of tools. And I've always loved the satisfaction triangle. It comes from, some people attribute it to different sources. I remember Chris Moore using it in training that he did. There's a social psychologist at the University of Virginia, who I'm embarrassed to say I don't remember, may have actually been the origin of this, but people's satisfaction with the choice of the process and how it's conducted really can be thought of in three categories. It's about the substance of the issues for sure, and whether their interests are being met. But it's also, they have concerns about the process. How expensive is it going to be for them to participate? Do they feel it's legitimate in terms of all the perspectives being at the table? I mediated the EPA's lead and copper rule just as the Flint crisis emerged, and there were disputes over who should be at the table. And then relationships matter. So I won't read all of these things, but I loved the quote in the, you can read it faster than I can say them, in the CEQ report on collaborative NEPA, which was a handbook for NEPA practitioners. Collaboration is a broadly used term that describes how people and organizations work together, literally meaning co-labor. There are many ways to collaborate, informally or formally, as partners or in teams, in advisory capacities, or as joint decision makers. But this is what I want to underscore. When we collaborate with someone, we allow that person a relatively high level of influence in our decision making. And that's another application of Michael's word, respect. Respect goes a long way in successful collaboration. So next slide. So I may be wrong about the date here, Will, so I apologize if this is a typo. My memory was that the Negotiated Rulemaking Act was 1990. I had an old slide, but maybe it was 96. But one of the things that agencies can feel comfortable about, I think, in this period of change and some uncertainty about deference with Loper-Bright, that they have a clear statutory framework. It's not all uncertain. And many agencies have used it successfully. So, but back to the sort of Negotiated Rulemaking Act, it itself is built on a solid base of analysis and experience. So the Administrative Conference of the US, ACUS, issued a report that is really credited with being the precipitating work for the Negotiated Rulemaking Act. But there were many private initiatives like the policy dialogues at the Conservation Foundation on chemicals policy. The Toxic Substances Control Act was passed in the late 1970s. Resolve was part of the Conservation Foundation for a period, and so I was part of those. But J. Clarence Davies was one of the authors of the Toxic Substances Control Act, and he had the credibility as a having got into the private sector, into this think tank, to bring people together. The challenge of that was that I did the book that Will referenced Thank you, Will. It was indeed passed in 1990. I am aging, and I do have an aging memory. But anyway, that book that I wrote on the first decade of mediated environmental disputes, with which Howard Feldman was a key player, one of the statistically significant factors in whether agreements got implemented was whether the implementing agency was at the table. And that was 200 cases. So the Conservation Foundation had this lovely thought of business and environmental interests getting together, and the agency would appreciate it. And in fact, the Negotiated Rulemaking Act made a big step forward in having at least the choice for the agency to be at the table. I think that's a choice the agency should make. EPA did in most of the Safe Drinking Water Act negotiated rulemakings that I mediated. So anyway, lots of experience by many agencies. These are just a few examples. As Will said, it hasn't been used as much in recent years, but EPA used it for very complicated regulations involving major public health questions. So deep well injection of hazardous waste, disinfection byproducts in drinking water, total coliform rule in drinking water, lead and copper rule. I mediated a Federal Trade Commission negotiated rulemaking on the lemon law rules, which didn't have this kind of scientific uncertainty, but was very complicated. And then Nuclear Regulatory Commission convened one on low-level radioactive waste years and years ago. And I understand that Department of Education and DOI and others, I actually did a small regneg, they called it a regneg, I'm not sure if it was, for BLM on the rules applying to the film industry for use of public lands. So there's some examples back there. So my own personal opinion is that the results, not scientific, met more interests. In the drinking water rules, the regulatory agents, the regulated water utilities brought one estimate by EPA, an informal one for the first disinfection byproducts rule making was $1 million worth of information collection and analysis to the table. So don't know how widespread that is, but an incredible benefit. They do take effort, time and effort. So I don't think that we should blanket recommend negotiated rulemakings for everything. It should be used where the stakes are high, where there's a big public benefit and concern. The one comment that's made over and over about why negotiated rulemaking isn't used very much is the Federal Advisory Committee Act. I do not buy that. I do not think that's a serious problem. EPA, and I saw Deb Dalton was on, maybe she could even speak to this if we have time, I'm not sure, but they had a dedicated person who had experience working with OMB to get Federal Advisory Committees chartered. It really didn't take very long. And Debbie and Chris Kurtz did a really good job of moving that through. And then we also used the copper rule, used a standing Federal Advisory Committee, and the agency convened a subcommittee. So that's also a way. There's a reason for the Federal Advisory Committee Act. It has good principles of making sure that there's a balance of interests at the table, for example. So it's got a bad rap, as I think I saw Susan put in. So just the last, I think this is just maybe a couple quick slides, basically to make one point, which is that there have been serious evaluations done and they've been positive. So the National Academy of Sciences convened a panel on public participation in environmental assessment and decision-making that issued its report in 2008 and made the following conclusions, very much along the lines of what we've been talking about, that these processes can improve the quality and do improve the quality and legitimacy of the decision, and it builds capacity. We're talking about being a democracy. We need to have the capacity to work together, in my view. So, and they concluded it leads to better results. So they made a recommendation that actually this was convened because some scientists were saying, are these rules getting dumbed down for agreement's sake? And the conclusion of the National Academy of Sciences was no. Environmental assessments and decisions should be supported with collaborative, broadly based, iterative and analytical deliberative processes. And I won't read all the rest of it. You can have the slides and look at that, but very strong support. And then finally, other than the list of resources, the OMB CEQ principles that Will mentioned, I had the 2005 one, not the 2012 one, ground us, actually go back up to that one, just real quick, ground us in some principles about clarity of purpose, inclusiveness, collaborative formulation and process design, and decision relevant information. There's a number of kinds of points there that, like the Negotiated Rulemaking Act, can provide agencies with an important grounding in the experience of this field over decades. So last slide are some of the resources. If people are interested in my little monograph from years ago on when the sparks fly, I'm happy to send out a PDF of that to people who want. So that's it. That's it from me, Susan.
All right. Well, thank you. Gosh, really thoughtful remarks. And yes, I will be sharing the slide decks. So we have a little bit of time for questions, and a few of us may be able to stay past our stop time in 7 or 8 minutes if others can stay on. So in the meantime, what questions y'all have? Or comments?
Let me make a comment.
If someone's trying to talk, we cannot hear you.
Michael, we can't hear you.
Can you hear me now?
Barely.
A little bit better.
Close as I can. Is that any better?
Go ahead.
Just go ahead.
Yeah, I mean, you were coming in really loud and clear during your remarks, but give it a try.
Well, anyway, just very briefly, I was counsel to the Blue Ribbon Commission on America's Nuclear Future, which was a federal advisory committee to the Secretary of Energy a dozen years ago about nuclear waste disposal. And we didn't have a problem complying with the Federal Advisory Committee Act. We just had to inform the Secretary's designated representative ahead of time what the subjects were going to be cleared. There had to be public notice with an adequate amount of time and the subjects to be covered. And the public had to have a right to speak at the end. And we covered those bases and really didn't have an issue with FOXA.
Okay, thanks, Michael. For those that might not have heard him, he said that he participated in an advisory committee a while back and didn't seem to think it was problematic and that the requirements were not too onerous. So what other comments and questions do folks have? Howard, you've been listening quietly with your camera on, which I always appreciate. And as one of the long-term folks in the field, what's on your mind?
Well, first of all, I think the 3 presentations were wonderful. I'm not used to such good presentations. So to have 3 people in a row make such extraordinary presentations is really great. And thank you all for that. I would just say that back in the day that Gail and I at least remember, there was very little legal structure around the processes that we're talking about. It was supported more by politics, and I don't mean that in any pejorative sense. It was a politically efficacious process. And in every way. And I think that as time passes, and this is just life in America, legal processes sort of grow up around political realities and political good government or cynical government or whatever. I think, but I would say that political component that seemed to reinforce what we were doing when these processes were flourishing in the absence of legal support continues to be a factor that's present on the scene. The politics are present. And the question that I think is begged is whether or not the current political climate makes these processes as appealing as they once were in other political climates. And I think that people like me and Gail and others are chronically optimistic because we think that these processes are good government. Whether they're good politics is another question as to whether they're good government. But I think that there is something inherent in this collaborative mode that makes it good politics ultimately, and that's the basis for some optimism here. And I was glad to hear Michael's presentation because it seems to me that that point of view, my point of view that I'm trying to express, is actually consistent with his reading of the legal developments. So, that somehow the sensibleness of it all will prevail. And
just to build on what Howard's saying, so in the Missouri River project, this advisory committee, the Corps of Engineers is responsible for two things. In addition to the ESA compliance, they're responsible for implementing authorization from Congress, a direction from Congress to purchase and restore 166,000 acres of native habitat. However, the appropriations for that were suspended for 13 years because of politics, because the concerns of the small poor rural counties, they started to realize the impact on them in terms of tax loss and changes in their community structure. And so they were able to stop the implementation of a statute. One of the things, and there's lots of details about the back and forth of when, and currently the Corps is quite focused on a collaborative relationship. It wasn't always, I don't think, but the common sense prevailing. One of the things that some of the really politically powerful advocates for the rural counties and for agriculture recognize that they still are going to Congress, and it makes my job chairing this committee much harder because people are fighting over which forum people are using. They feel a little betrayed, but everybody recognizes that this collaborative forum is better than it going to court and having a judge decide. So we have three branches of government. Courts have an incredibly important roles that Michael was alluding to, and we all know. But the stakeholders, the players, the political players, don't want a judge to decide. They see they have more influence over their interests. This is not on the interpretation of a law. It's on whether the law is being complied with, I guess. But they aren't going all the way toward just trying to end it forever, because they see the collaborative forum in a commonsensical way as where their interests can really be played out and satisfied, as long as they're really listened to. So anyway, I just underscore what Howard's saying.
Thank you.
Yeah.
Yeah. Well, thank you, everyone. I do see that time to end this webinar today. And I can stay on if people want to have lingering thoughts or questions and you want to stay on, great. And if not, thank you everyone for coming, and stay tuned for part 2 of this conversation, where we as a professional association at ACR EPP will ask ourselves, is there anything we can do to promote the use of collaborative governance during this uncertain time? And thank you again, really wonderful panelists, Will, Gail, and Michael. And
Thank you
you
for
all,
including me.
yeah,
Yeah, thanks for inviting me.
Yeah, thanks a lot,
yeah.
Susan.
All righty.
Bye now.
Bye.
Bye all. Thank you.
Bye. Let's see, Emily, I missed the name of the Missouri. Emily, are you still with us? Yeah. She missed the name of Gail's collaborative. I know it's referred to as Mr. Rick.
Susan, I can follow up with Emily. I'm working with her on a project.
Perfect. Thank you.
You bet.
Thanks, Sarah.
All right. Well,
Good to hear you,
Bye.
Sarah.
Hey, Mary.
Hi.
Likewise.
yeah, well, for folks that are still with us, any final comments or questions?
Well, I actually have one from Michael. Maybe we can get it to him somehow. I really want to dig into this point he made about how courts are really likely to look favorably on collaborative activities that do the hard work of coming up with the evidence that's necessary to support the decisions. And I'd like to know more. We as internal neutrals that advise people on this all the time, what can we be advising them? What will help that? Because I think it's a really interesting point. It's one of my big takeaways from the session today.
Yeah. Yeah, that's a great question. Yeah, that's one of my takeaways, as well as it seems that Loper Bright does not mean the end of the administrative state for environmental regulation, that it's not, maybe the sky is not falling like we all thought it was originally.
Yeah, I think it would be interesting to see if there could be another conversation around joint data development as a centering for the local implementer and the federal regulator to build that shared evidentiary chain of data and sets of investment. So I think that's at a very locally level, very interesting to folks who come to these tables, not as conveners, but as invited participants.
Yeah, I mean, that joint fact finding that Gail mentioned seems like it could be even more important now. Instead of having fighting scientists arguing that their science is better, actually develop the data and the science together.
Well, as well as the questions, right? I mean, I think that's one of the key things about joint fact finding, is that you're collaborative even on what the inquiry is.
Yes.
Whereas usually it's the government agency that's driving the asking.
Right. Great.
Thanks.
Alrighty. Well, yeah, and thank you, Will, for getting us thinking and going on this. I'm glad that you posed the questions originally. You are the responsible party here. But I took it and ran with it, and Mary got excited about it, and Stephanie Lucerdo got it. So yeah.
I'm glad you all did. I think it's great. I think we're off to the races in terms of the conversation, and that's a really good thing.
Yeah. Okay.
And I thank you all.
Bye, everybody.
Oh, Mary, what were you going to say? I'm sorry.
I just wonder if we could all be bridging what we're learning from TEK, traditional ecological knowledge, and how the feds have had to build an interlocator in their processes for managing that kind of unique data and evidentiary set. Maybe that'll help our imaginations, because we've been doing this the last few decades with tribes coming online with their own way of talking and sharing relevant data and evidence. So I think we're already doing it in some circles. Maybe we're just expanding the pie.
Right. Okay. Any other words for the wise here?
Hey, Mary, this is Sarah. That's really interesting to me. And I'd love to talk to you more about it offline since this is being recorded.
Good timing. Happy to.
Great.